Approval of the minutes of the previous meeting. Motion by Supervisor Frazier, second by Supervisor Montesi. Any discussion? Hearing none. All those in favor?
Aye.
Any opposed? All right, first up today is the Sheriff's Office. Turn it over to Sean.
Good afternoon. Does everybody have a copy of our agenda?
No.
You didn't get one right here.
Oh,
Yes.
I'll take yours. But yes, yeah.
And then the other.
Yeah, he had one, but didn't notice it.
That's the first thing.
Sheriff's Office has a very light agenda for today. Under the action agenda, item A is request a resolution to amend the budget to transfer monies consisting of $93,100 within a PSAP grant, which amends resolution 111 of 2016. Basically, the monies were already there, we're just shifting it from one code to another code.
There's a motion to make the move. Supervisor Dickens, second by Supervisor McDonald. Any discussion? Hearing none. All those in favor?
Aye.
Any opposed? Carries.
Item B is request permission to have Patrol Officer Kuhn and Patrol Officer Carpenter attend the Child Passenger Safety Training Conference, which is held May 10th through the 12th this year up in Lake Placid. It's part of maintaining their child passenger safety certifications.
We have a motion. Supervisor Simpson, second by Supervisor Montesi. Any discussion? Hearing none. All those in favor?
Aye.
Any opposed? That carries.
Item C is notice of intent to fill a vacant patrol officer position due to retirement. Patrol Officer Gould is retiring the end of this month.
Okay. We have a motion to fill the vacancy. Supervisor Dickinson, second by Supervisor Bramer. Any discussion? Hearing none. All those in favor?
Aye.
Any opposed? That carries.
Item D is a notice of intent to fill a vacant position, communication officer. Blair Davies is retiring with Lehigh County for close to 30 years.
All right, do we have a motion? Supervisor Vanslo, second by Supervisor Bramer. Any discussion? Hearing none. All those in favor?
Aye.
Any opposed? That carries.
Under topics for discussion, I have listed as a pre-post resolution request, which was put to the board last week, to amend the budget to reflect an insurance recovery in the amount of $28,621. This reflects the insurance recovery on one of our patrol cars, which was destroyed in an accident a month and a half ago.
And we've already taken care of that at the board meeting last Friday.
Correct.
So we're just
so you're aware that it went through.
wanted to make sure. I know Supervisor Thomas had asked me about it at the meeting, so sure everybody knew.
And the only other item that's not listed on there, we had sent a notice to fill the position for Patrol Officer Maurice Aldrich, who retired back on April 8th. And I was informed this morning that today that would go through the committee.
Okay. Hold a minute. I think the Sheriff, did you have something?
Well, I did on the last thing. I just wanted the board to be aware of something that the undersheriff took it upon himself to change within the last 6 months. And as you know, we're self-insured. So in the past, when we lose a car, if we had a new car with say 1,000 miles on it, we'd have to eat that. But we changed the insurance over. So these are protected now. Sean, would you explain that to them so they understand why we're getting this money back, which we wouldn't have gotten back a year ago?
As of July 15th last year, all of our vehicles that we consider our first line patrol car, not spares, not school cars, not asset forfeiture vehicles, or any of the vehicles we received through the military, vehicles that we've gone out and purchased that actually have a value of $10,000 or more, now have full comprehensive coverage on them, much like you would have on your own vehicle. Previous to that, they only had liability coverage. So the way our policy works, we get full replacement costs on a vehicle. It's not what the vehicle costs now, or I should say, what the vehicle is worth now. So, for instance, this was a 2014 patrol car with less than 30,000 miles. They pay what it costs to replace it with a 2016 with all of the same equipment on it. So the county is not at a loss in the end. We have a $500 deductible, but we're still okay.
Excellent. Supervisor Brock, did you have something?
Yeah, I was just curious to know what a new car costs.
About $29,000, if I think, put everything on it.
Correct.
Yeah. We had most of the equipment was able to be transferred from the old car to the new car. That's why it doesn't cost that much.
Okay.
Okay, anything else for the Sheriff's Office? All right, well, thank you very much. We appreciate your time this
Thank you.
afternoon. We'll move on to emergency services.
Glad to see you again.
More training today?
I don't know about that, man. Trees.
Whenever you're ready, Brian, I think we can take it away.
Thank you, Supervisor Wood. The first item under action business, resolution for the reappointment and appointment of the members of the Fire Advisory Board. These appointments, the current ones expire on April 30th. This is the Fire Advisory Board, which is made up of fire chiefs and leaders in the fire community, and we meet on a semi-monthly basis, and at that point in time, we discuss all the things that's going on.
Okay, motion by Supervisor Montesi, do I have a second? Supervisor Simpson, any discussion on this? Hearing none, all those in favor?
Aye.
Any opposed? That carries.
Number 2 is a request to establish a contract with a company called Tetra Tech, and this is a result of a request for proposals that Amy and the purchasing department put together to provide Warren County with assistance in emergency planning, training, and exercise. If you need descriptions on that or what it's all about, Amy is here to explain that.
Do we have a motion to get it on the floor? Supervisor Frazier, do we have a second? Supervisor Montesi, any discussion? Hearing none, all those in favor? Any opposed? That carries.
Item 3 is very similar, establish a contract with Tetra Tech, and this is a different request that I'm out there, and this is for assistance with emergency response, debris monitoring services, and cost recovery. These are all plans and things that would be necessary should we have a major event. This will assist us in getting our FEMA recovery as well as helping out our citizens.
I'll put it on the floor and
Motion by Supervisor Montesi to get it on the floor, seconded by Supervisor Bramer. Supervisor Montesi, did you?
how much does it cost us, both of these?
Go ahead.
There's not a set dollar amount. It's not like we have a contract not to exceed X, Y, and Z dollar amount with these particular vendors. So with the first one, for the planning exercises and training, the way we worded it is as costs or as funds become available. So right now, in our 2016 budget, we have money in the OES budget to start a continuity plan for the entire county when we talked about finishing it next year. So we already have that money in place. We have a grant that's going to start at the beginning of 2017 for another exercise, a regional exercise within the 7 counties that we would do the hazmat responses.
So how much money is that that's set aside?
For which one?
Well, the first one.
For the COOP plan, we only put half the money in the budget.
For $37,000, half of $75,000.
So this is a pretty expensive proposition, huh?
The Ready Coop plan
$75,000?
is $75,000, and when we met with our budget committee at that time, we determined that was a big hit to add to our budget in 1 year. So we asked them if we could split it and get half of that money in 2016, the other half in our 2017 budget. So this plan truly won't be finished until 2017, but we had to get the funding stream started.
And then, so then the second one is how much?
The exercise is around $40,000. That's through one of the grants that we applied for.
Okay.
And as other things come up that warrant getting assistance, and as we have funds available, we'll reach out to them to do that. As far as the second one is concerned, that's all response and recovery. So let's keep our fingers crossed that while we have this contract, we will never have to call them and utilize them for that. If it's a small situation, obviously Brian and myself and the other people that we have here within the county, we're going to handle it. But if it's something large and devastating like Hurricane Sandy hitting us, even Hurricane Irene, we were at our limit, and probably we exceeded our limit at that point in time. So if we had another Hurricane Irene, we might enlist their assistance in helping us get through that time.
What would they do? for instance, if you had to call them, what would be their?
We have this specifically broken down into 3 different categories for response and recovery. One is additional help in the emergency operating center or in the field if that need be. They have qualified people who have worked on our level before, the local, county, state level, federal response folks who know how to work in an EOC. Now, we have had training here, a lot of our department heads had training how to work in our EOC, but they don't have that experience. So these are just a few people to fill in and have that experience, and then we use our department heads as that local flavor people who know what the specific little things that work in Warren County. So they're gonna help us out there. The next one is debris monitoring. Now, that sounds really possibly stupid and a waste of money. But if we want to get our max amount of money back from the federal government, when we have a federal presidential declaration, and we have tons and tons, literally tons of debris, and it's labeled, you know, you might have like white goods, like which are old appliances and stuff, regular table garbage that you have, then you have trees that have fallen down, and then there's just construction debris, houses that can't be utilized anymore. Those are all broken down into various categories. You need someone, this is the federal government terminology, you need someone who is qualified, who is certified to sit there and say, okay, you have so many cubic yards of this particular type of debris, and then you have someone at the other end of wherever it's going to saying, yes, so many cubic yards have arrived here, and they are being processed according to the federal government's guidelines. By doing this, we're going to be able to get money back. Currently, we don't have a plan in place for doing that, nor do we have a contract with qualified people who can handle this.
So, the 40,000 or the 75,000 is initially for training to train you folks, our folks, on all of these procedures. Now, if you well, if you call them in, let's say we did have something like Irene, and you had to call them in, do we pay extra for that? For those people that are going to be in a communication center, or?
This contract here is, yes, it incorporates paying them. So in paying them, the 3rd category for response and recovery is the actual, the cost recovery. So we would have them assist the towns in particular. I know like Hague and Horton and Johnsburg definitely have had a lot of experience sitting down with FEMA and with the Office of Emergency Management, filling out all those forms, going around to all the various locations that have incurred damages. So when we're hiring these folks and they're coming out for a Hurricane Irene type of event, all the money that we are giving them, we can put on one of those sheets to get reimbursement for as well. Is there a local match to it? Yes, there is, just like when you're doing everything else. There's also a local match for when Brian and I show up in the Emergency Operating Center as well.
But I mean, that money that you pay them is above and beyond these two contracts.
This is hourly. This is as needed. These bids went out on an hourly basis. Project manager, laborer, investigator, you know, all those things. And we compared, the first one had 7 bids and the second one had 4. So we actually compared all of those companies with their experience, what it is they're capable of doing, and bottom line is, what do you charge per hour for a guy to be in the EOC? And that's how we scored how this is. This is an as-needed basis. It's not, we're not buying a job. This is what, we need this in place, so if we need these people in a hurry, I can't go out to bid in the middle of a storm and ask for prices.
Okay, but, so the dollar amount that you set aside, 37,000, are we gonna spend that, or is
Yes,
it
yes.
in reserve? How are we
We're gonna spend that
on what?
on the COOP plan, the continuity of operations plan.
All right, so that's what I asked before. There is a plan that you're paying for, and then the implement, doing the covering a disaster is a separate item, right?
It's a separate contract altogether. There's 2 separate contracts here.
Yeah.
So the second contract that has to do with response and recovery, there's no flat initial fee that we have to upfront these folks. All we're gonna do is have a contract with them. If we ever have a disaster that warrants us calling them, then we will call them, and then and only then will they get paid.
So do
We'll
we
have all
have
the
to put,
pricing and everything free,
do we have to put
everything will
that,
be in place, I'm
do
sorry.
we have to put that money in a budget?
No.
Okay.
Not at all.
Kinda strange.
The point I was trying to make, Ron, is the 37,000 and the 40,000, those are items we're going to use with this contract. But they are not just for that that contract can be used with this vendor for any other projects that we need. We don't have to spell them out. In this particular case, we know how much money we're gonna spend on that
On
particular
the
item.
plan, okay.
But it doesn't preclude us. It doesn't mean those are the only two items we can do with that contract.
All right, any other questions? Hearing none, we'll call the question. All those in favor? Aye. Any opposed? Carries.
Okay, pending items, we have the pending item of the storage building. Some of you were involved with the discussion earlier today in the facilities meeting. I don't know, Supervisor Wood, do you wanna keep,
At this point, I think I'd take it off of our pending items. It's been, the financing has been referred over to finance, so I think it's pretty much gone out of our committee and out of our hands at this point. But if anybody's interested, certainly during finance, bring that up. Do you have any other items this afternoon, Brian? Claudia's got a question?
Thank you. Maybe we could do a similar motion supporting that going up to finance, the one about the use of the Perkins Recycling Building. Does that make any sense, or?
We can if you want to. I'm not sure we need to, because there's already one going to finance. I don't know if we really need to do a second.
I just don't want it to get to finance and have them say, well, what does emergency services say?
Well, I believe finance, referred it and kind of made their decision how they wanted it to go, and, county facilities essentially confirmed that. They were just waiting, and I think it says on here, they were just waiting to determine the costs. If you remember the finance meeting last month, they already determined, and county facilities has already determined, that they want to use the building. So essentially, finance, I believe, was just waiting for the actual estimates of the cost, which they did this morning, so. Rachel?
May I just ask a follow-up question about that? Where is the source of funding for that
That's up to
22,000?
finance. They're gonna have to designate a source of funding for that.
So finance makes that determination?
Yes, yep.
Thank you.
I will add one thing to that, you know, I can't let it go. I would like very much this committee to support me when we come time for our 2017 budget, that I would like to start putting some money aside so that we can actually construct the right building. So at that time, hopefully I'll be able to ask for your support, and so we can do this right.
Brian, I just wanna ask you one question. If the people that are renting the building at Ciba-Geigy suddenly leave or go bankrupt or whatever, is that building suitable?
No.
Okay, so,
Would you like to know why?
well, I mean, you,
Well-
we beat it up pretty good this morning, but.
Yeah, well, no, the problem is, Ron, the space that would be available to us only changes around the corner that has no access by doors. That's where their manufacturing or recycling equipment is. Putting more equipment in there end to end, or sneaking it in around, yeah. If this was firewood, or if I was, storing cars for the winter, that would work. That's not what we're doing. We have vehicles, we need to be able to get out, and not necessarily take, you know, an hour and a half to get them out. So, yes, if they moved out, would there be more space available?
That's
For
what
sure.
I'm saying.
For sure, yes, there would. And that being said, I don't know what that story is. Some people tell me they think that, they may be in trouble, or what's happening, what's not happening. I don't know. That is one of the concerns I have, I did not raise this morning. The electricity for that building and the operation of the heat and stuff is being provided by them. Should they decide to bail out, or not pay their National Grid bill, as we have seen before, and that gets shut off, where does that leave me? So I just throw those things out there. There's things that I think about that perhaps other people don't. So, again, I'm not fighting, I agree with it's great, those guys are gonna put that together for me down there, and we'll use it as best we can. But I will put you on notice that I do not consider that our final resting place.
Excellent. Mr. Dickinson?
I'd like to be put on notice. I object to his attitude, and I object to his, not being satisfied with the building. He's getting his vehicles undercover, it's in a heated building. We're doing it for less than 5% of what he came in here originally with. decision's not his, it's ours. And I object to him putting money away for a building he may not necessarily need on taxpayers' money.
Okay, thank you for your thoughts, Supervisor Dickinson. Anybody else? Okay, we'll move on to assigned counsel.
Thank you.
Bullshit. Tom, we would sign council.
What's that? I'd be happy. Sure you wanna hear me that?
Well, him
I was gonna say, don't ask him.
Don't ask me.
No, you're him. You're all right,
Say.
for the moment.
Make sure Ron gets one.
I may not have my flip-flops on today, but.
Firing up there, Johnny.
Took
Maybe
my
I'll call you
impression
Donnie.
to go down
Mike,
and
did
look
they
at the
change
building,
it all,
they were
or?
great about it.
Excuse me, okay, thank you.
To the office tomorrow.
I'm not
feeling
even
great
gonna
about
get
how
you
no
going
one
on it.
invited
I
me
am
down.
wearing jeans tomorrow.
Well, it wasn't really the thing,
Maybe
I went
short.
down on my own. I
Oh, you
mentioned-
weren't part of the, little,
Well, I mentioned it to some other people, and they wanted to go, and
I wanted up here.
there wasn't an open invitation. The building's open. Call Jeffrey, he'll take
This is more than I,
You should do that.
I think
First of all,
I read the thing.
I only reservation money split and then paying money something later on down the road. I just don't like that open-endedness.
Yeah, mine throw $6,000 away for some study, they came back. Yeah.
That was one point to him now, we found a place for you to put, you're not getting another one.
All right,
No,
let's
I'd
proceed.
rather see us
resolution that
get,
passed,
get our
temporary.
money's worth
Let's
out
not
of it.
make me gavel the committee excessively.
Yeah.
You like to proceed?
Big building. Yeah, more than enough room.
Here today to
Right,
give you
David.
the update on the new unfunded mandate that we received as of April 4th. If you could refer to your packet.
I read it in the paper.
Pardon me?
I said, I read it in the paper.
You read it in the paper? Well, this is the truth.
I'm moving down this.
I like that, I like that. The rest of the story, right?
I assumed everybody had some sort of an opportunity to read the initial page and a half that I synopsized for you from the 87-page report. And I'd like to just move on directly to the new eligibility criteria, so you understand what's actually gonna change for the office and the way it's run. Number one, this office has never presumed to find ineligible or eligible. A decision is always made based upon the information provided. So that's not a big change. 2A is also, that's a huge change. That's a 250% federal poverty guideline. That's what everybody in the state is supposed to use now, and almost every county has always used 125%. So that's gonna possibly double the amount of people applying or potentially eligible. That will be a significant budget impact, and I'm talking real quick, because these are supposed to be in place for October 6th, the new rules and procedures. Let's see. Applicants are always eligible that were incarcerated, detained, or confined to a mental facility, and I also included hospitalized, if they're unable to get the paperwork that they need. My office never assumed that people that receive SNAP benefits, family assistance, any of the things listed there, SSI, Medicaid, PUD, never assumed that anyone was eligible or ineligible, like I just said. They had to provide the information so that there could be a determination made. Let's see, D, under number 2. The rule in our office, well, my office, was that every 30 days, because of the changeable nature and the transient nature of the people that applied, if they were within the month, if they had more than one, say, a charge, they would come and they would be deemed eligible still. Now, the new mandate wants us to stretch that to 6 months. That, and I say stretch, and I mean that literally, because, again, the transient nature, recidivism, repeat offenders, the nature of family court applications, it's like a big circle. It goes round and round. Number 3, nothing's really changed. I never considered the ability to post bond, standing alone, that would make someone ineligible for counsel. They were automatically assigned, especially when they're incarcerated. Number 4 is a considerable change. Since 2004, this office has considered third-party income. For example, parents with minor children who either stole from their parents or wrecked their car. The parents oftentimes did not want to provide that information, but realized because the child was a minor, that's their responsibility. But this has changed now, according to these rules and guidelines. Same thing for spouses living together and filing jointly. Now they can come in and each apply and are looked at as an individual as opposed to a couple sharing income, sharing expenses. That's the big one. There was a lot of discussion prior to these rules coming out that was gonna be a potential problem. But again, this is all brand new for everybody. This will also increase client volume because everybody's now an individual as opposed to a family unit. That could be a potential problem. Numbers 5 through 8, this office has always followed all those policies, so nothing new there. As far as procedures, let's see, the newest one there, the first one, criteria shall be applied uniformly, consistently, and transparently, that's always been done. Number 2, let's see, is it number 2? Sorry, I'm not flipping my pages fast enough. Well, 1 and 2A, that's nothing's changed, those are the same, but B, under number 2, this is new and has little to no impact on the office because there is no entity. I am the entity, I'm it. The court doesn't really do any designations unless it's at the bench on arraignment and things of that nature. Everything else, they defer to me to do the assignment. Let's see, moving on, try to do this fast because it's a lot of information. Number 3, these are all new. Since 2004, the office has always followed the initial listed policy. All applicant information shall be confidentially preserved during the application process. Always done that. A through C, however, are slightly different. A, interview will be done in a confidential setting. This is problematic rule. I've always strictly monitored the hall traffic to maintain the most confidential environment for the clients. My current location is not conducive to true confidentiality for applicants, all applicants. Do you know where my office is?
Yes.
Does everybody know where my office is? You do? Okay. You can understand why it would be hard to maintain confidentiality when you're in the middle of a hall, there's other offices on either end, and they're speaking to me through plexiglass. So everything they say is out in the hall for everybody to hear. Let's see.
And what's the date that we have to conform?
October 6th, these go into effect. I've already started changing through some of the rules just to update it and be on board right on time.
So, will you go to facilities?
That's right in my next couple of, you beat me to the punch now.
Well, I visited you, and I was surprised that...
And you are part of my notes, right here.
a two-person office would spend $1 million a year, and it was, that was a big budget.
It certainly isn't spent on me,
I
I can
know
tell you
that, yeah.
This aspect of the new procedure is also problematic due to the location of my office, as I said. I've discussed with Mr. Montesi that a physical change will be needed in order to accomplish this. I'm told this may need to be addressed with the facilities committee and buildings and grounds. I haven't a clue how you could make it more confidential, because it is in the middle of a hall. I don't know if you want to build a little shed outside, you know, put a soundproof door on it, I have no idea. Construction is not my area of expertise, so I would defer to whoever has that expertise. Does that work, Ron?
Yeah.
Okay, good. A screener will only disclose information to the court, no one else. This is an interesting one. Since 2004, no applicant information was ever disclosed unless under subpoena from the DA's office. To be used for prosecutorial purposes, I assume. Now it is my assumption that this is no longer allowed at all unless under court orders. This is an assumption on my part. I don't know. These are all so new for everyone. There's no way for me to know what the intent of this writing was. So I leave that open to interpretation until another meeting can be had. Information, let's see, 3C, information will be submitted ex parte, will be sealed from public view. That's always been done. And moving on to number 4, counsel shall be assigned at first appearance and immediately following request for counsel, whichever is earlier. This came on board in July 2015, but was seriously geared up, and Kate can attest, in October 2015. This has little or no impact on this office, as the PD's office covers all arraignments and conflicts, and any conflicts that are determined as a result are then assigned out by this office. Okay, you want that now? Okay, moving on to
5A.
Bear with me, 5A? Nope, I skipped one, sorry. No, it's 4A. Determination should be done in timely fashion so the assignment of counsel is not delayed. This office has always strongly struck 4 to 24 hours for assignment, and that's not difficult to do. B is new. This office has not made provisional appointments. This has always been the determination of the presiding judge and will remain so, because there's no need for me to get involved with what the judge determines as a provisional appointment. Now we're on 5. The eligibility determination should not be unduly burdensome or onerous. This office is always ascribed to that. I try and make it as simple as possible for every applicant. 5A is new. Applicants are not required to attest under penalty of perjury to the truth of the information provided. Our application that's currently in use is the second part of your packet. Page 3 and 4. And you can compare it to the new one, which is on top of it, that is the proposed new application. It doesn't address a lot of the issues that PDs may need to know and are only accessible through me, whether or not there's prior criminal records, which they can also access, whether or not they're a U.S. citizen, etc. So the application will no longer be notarized.
Supervisor Seaver, did you have a question?
I do, thank you. Joy, I'm just wondering, much like we have, public assistance fraud investigations, do we have any system in place that verifies what, applicants are putting, I'm just shaking your head no.
Absolutely not.
Is that something
I'm
that?
the investigator too.
And you're the investigator?
We prosecuted people who are offering up false documents for filing when we know that they have an income and they don't disclose it. And we've prosecuted drug dealers who we know are making money and say that they don't give any money, because I'm not gonna have the public pay for a drug dealer's,
Yeah.
attorney.
And there's probably been a dozen over the years that I've initiated, knowing that the information is false based on information I received from the public, so. But there is no part of my budget that involves an investigator.
I just didn't know if there could be if I may, thank you, if there is some type of an informal arrangement or an agreement that could be looked at with the sheriff's office, much like the social services,
Well,
to
it's kind of a
investigate.
word of mouth kind of thing. If I think somebody's given us false information, I'll just follow up.
Got you.
Which is really not what I should be doing.
Sure.
I mean, it should be a separate entity altogether, because that brings into conflict what it is I actually do.
Right.
So, that is
Yeah.
something that we need to be addressed.
Who would prompt the liberalization of all of these rules? I mean, that in essence what it is, but what's the governing body that pushes for this?
Office of Indigent Legal Services. It's based on the constitutional right to counsel. You've heard of the Miranda warning?
Yeah.
That's what it's based on. If you cannot afford one will be appointed for you. But who gets the onerous task of deciding, running over the financials, and who gets to decide if you can't afford one? Because the courts have basically washed their hands of it.
But I mean, our system seems to have been working, but it's now even a little more liberal then, right?
Oh, I would say, yes. But that wouldn't be that's not my cross to bear, unfortunately. I'm just the bearer of bad news. Okay, moving on. Where were we, Ron? 5?
I see.
Let's see. Okay. 5. Oh, well, 5C. Applicants are not required to produce unduly burdensome documentation to verify they are provided. Applicants shall not be denied counsel solely for failure to produce documentation where they have demonstrated good faith effort to produce requested documentation. Well, that's a very liberal interpretation of good faith effort. The bulk of the parties that come to me do not make a good faith effort, even with the simplest documentation. Some will not provide a driver's license, they don't provide charges. Whether or not I'm allowed to make a determination on that basis, I don't know based on this. That's something I have to obviously go to Oils about, Office of Indigent Legal Services for a determination. In connection with Mr. Reichenbach, he be kind enough to either attend the meeting with me on the 27th that is gonna address all these new rules and guidelines?
That's excited.
I need the attorney in my pocket when I go there.
Won't be in your pocket.
It would be very helpful to have you there, let's put it that way. 5B, this has always been the policy of the office, inability to retain private counsel. It does not need to be demonstrated, obviously they're there because they can't afford counsel, and looking at their financials tells you that that can't be done, based on the price of lawyers nowadays. So, number 6, A and B are new. These are new procedures for the office. This will increase office expenses. It is my opinion that the court will have very little to no involvement in this county where the new items are concerned. Those items being, screeners shall promptly inform applicants of eligibility recommendation. If denied, here's the rub, same will be in writing with instructions for reconsideration or appeal. I've always done that word of mouth by telephone. Technically, I probably shouldn't be doing the appeal process and the reconsideration. Reconsideration, yes, but the appeal process should not be in my hands, just as far as I'm concerned, as a conflict. Because I did the initial determination and said no. So, does that mean that goes to another entity in the county? Does that mean it gets farmed out to private counsel that has to be brought on board via contract? I don't know what that means. And that's why I'm bringing all this up now, because there is a potential for a major budget increase in my $1 million budget run. If the court determines an applicant is ineligible, like I said before, the court very rarely does that. 9 out of 10 times they will just assign one from the bench, tell them to come see me, and then they have me make the determination. So I don't see the court as being involved in that process, in addition to their already burgeoning caseloads. I don't see that happening. Let's see, number 7. These are all new procedures. Determination of eligibility shall not be re-examined absent a substantial change in applicant circumstances, such as the defendant can pay for a qualified attorney and the expenses necessary as a competent defense. Who makes the determination of a substantial change? I have no idea. I don't have an investigator, unless it's based on, again, on word of mouth or something the case office runs across. I have no way to know what that new information would be, because I'm out of that loop. So I don't really know what to do with that one, like a lot of it. And there will be no contingent assignments to applicants based on partial payment to the provider of the county, and then there's 7022D brought in. I've only tried 3 times in 12 years to get somebody pursued on 722D, and let's see, the second prior county attorney told me it would not be pursued due to lack of staff or time. So I didn't bother trying to pursue repayment for those that were deemed unqualified after they were assigned. And the last one is the easiest of the bunch, the data maintenance. I already do A1 and 2, and then 3 through 7 are things that would have to be addressed in my database, and I would need to meet with a senior programmer to address all those items listed, and it would also to make sure that all the data is in aggregate form only and that no individual can be identified through it. So, ask away. I have as many questions as you do.
Okay, so do we have any questions? Chairman Gary?
Yeah, but these are for, this is for attorneys that can't be assigned through the public defender's office, correct?
Correct.
Supervisor Brock?
Was Ron going down to get a lawyer when he showed up with that?
No, he wasn't.
Because otherwise, we need to check his income.
Any other questions?
Well, this is gonna affect your budget next year.
Oh, yeah. Big time. And I still don't have any idea how to tag numbers to it. Because it's all pretty subjective at this point until it's actually in effect and I can see where it runs.
And as I think you pointed out, now we have another family court judge, so the caseload will be bigger.
Absolutely. And if anybody knows any attorneys fresh blood.
Supervisor Seaver?
Thank you. I actually have a question about that. I spoke with Chairman Garrity and hoping to catch up with Supervisor Wood about some of my questions. I know Joy, I'm gonna get down there and see you in the next couple weeks. But you've just brought up, you know, attorneys to get on that list. I took a look at the local law a few days ago and I recognized that you have to be a member of the Warren County Bar, and,
Either work or reside in the county.
okay, I didn't see where it said work or reside within the county, but I thought it, are all of the lawyers on our list members of the Warren County Bar?
No, some of them are grandfathers.
So there's a grandfathered, okay.
They've been on the list since long before I was an employee here, and they continually take cases, and nobody's ever complained about the service, so I left them on. But when I initially started, I was told to put the chokehold on the attorney to keep the expenses down, and nobody else gets on the list that isn't a Warren County resident, residing or working, and is a member of the bar.
Does our local law have that grandfathered exception?
I'm not really sure. That's what I was
Okay.
instructed to do by the board at the time.
I would just, I mean, if it would be okay, maybe working with Supervisor Wood and the chairman to
Absolutely.
talk about some of these concerns. I've had a few inquiries from the public about how
Absolutely.
we go about those assignments, and then also, whether there's a cost-saving measures to looking at the conflict of, I believe it's called a conflict defender versus the assigned counsel versus public defender. So, I think there's a lot of discussion that could be had, and maybe involving the county attorney's office would be a good idea with Joy and starting to look at some of those ideas, if that would be okay.
Oh, absolutely.
Supervisor Montesquieu and Supervisor Brock?
One of the other things that Faye said, that she just asked if there, you know, attorneys, if everybody knows attorneys, they wanna get on a list. We exclude people that don't live in Warren County, and that's a question that we should be addressing. Should we, eliminate that and take folks from other counties?
Well, the reason that I think the original exclusion came into being is because they were trying to cut expenses, mileage, time on the road.
Right.
Things of that nature. I mean, it all ends up more money no matter what you do.
Supervisor
thought they
Brock?
were
Hold on, Supervisor Brock is next.
Yeah, how many clients do you have a year?
Oh, couple of thousand is minimum.
Couple thousand? And how many actually need an attorney, or do they all need
I
it?
would say 7, 8 of them need and get attorneys. Yeah, and it's gonna be worse now with this.
Go ahead, Supervisor.
Is there any way of triaging this, or?
Not according to the rules that they just gave me. That's the triage list I got.
Supervisor Bramer?
Thanks. I thought that attorneys were eligible from out of the county if they were a member of the Warren County Bar Association.
That was not as it was, I was instructed to do it when I started.
Supervisor Seaver again?
I think it is appropriate to try to have those discussions to firm up and give you some support on those guidelines.
I would love it.
But what also surprised me is that we don't have a training criteria for our lawyers taking these cases.
Right.
So, you know, unlike perhaps the Law Guardian program, and I think I'm using the wrong term by now.
Attorney for the child.
Thank you.
Yeah.
You know, there's criteria that they have to meet in order to be eligible to represent in those
Right.
cases, and it's my understanding that perhaps Saratoga County has those training criteria, but we don't in Warren County, and so how do we know, you know, the quality
Well,
or the
it's-
experience?
It's based on a, not a wink and a nod, I suppose. They're supposed to be updated on all their learning classes that they're supposed to have to be practicing at the bar to begin with. So the assumption is made that they're up to date on everything that they need. Whether or not that's the case,
Right.
I don't have the facilities to investigate it.
Okay, Supervisor Brock, and then we're gonna have to move it along, and complete the agenda, because we do have a need for an executive session. So Supervisor Brock?
Yeah, I'm just trying to get a handle on this. What kind of crimes, I mean,
The gamut.
but if you were to do a percentage, how many are very serious, how many are
We've
relatively?
had a lot of various serious cases this year and last year, but I'd say the bulk of the crimes are misdemeanors, violations, and low felonies, and a lot of family court.
Is there other ways of handling this other than going through the court system, or is there?
I don't know, that wouldn't have anything to do with me, they come to me because they're already in the court system.
but as we think about it, I would encourage the committee, if anybody has questions or thoughts, to relay them. Definitely, if you haven't been down to see the office, I would encourage everyone to do so. I got to see it again this morning, so, certainly if you haven't, please get down there. What do we?
This will be quick
Sure.
after all that bad news. I have Mary Livingston here from, Legal Aid Society of Northeastern New York. She represents the Saratoga office. And as it states on the agenda, I'm requesting an increase of $40,000 to their yearly contract to cover the second judge and additional personnel, which is what they will need in order to get up to par with the increased caseload as a direct result of the unfunded mandate. Any
Okay.
questions?
Do we have a motion to get it on the floor? Supervisor Bramer, second by Supervisor Montesi. Any questions or discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed? Carries.
Next is, increase in contract funds for the Rural Law Center. 2 seconds before I walked up here today, I just had a contact from the, Appellate Division Family Court. They have another appeal that's coming through next week, and that is the max on that 1-year contract, which expires the 30th.
Right, do we have?
They're looking for I would like to increase at least 6 to 8 cases of appeals a year, and, let's see, what did she give me? I did speak to Cynthia Feathers, who runs that entity. Here it is. This would increase the contract from $2,000 per appeal to $2,500. The program launched last year at low cost to 4 counties, and now an increase is necessary for future viability of the entity. What the leveraging dollars would be, they're supplementing all county contracts with funds from OCA and IOLA for family court appeals, working in few appeals per year along with retired appellate attorneys, former state assistant solicitor general and former public defender, John Wappett, who's now working there, who offer services pro bono, whenever possible, consolidating multiple appeals, of which there are many, by an individual litigant so they can count as one appeal for conflict. So they are really hauling a load for us, and it is saving us money in the long run.
All right, do we have a motion to get this on the floor? Supervisor Vanzo and Supervisor Simpson seconds it. Any discussion? Hearing none, all those in favor?
Aye.
Any opposed? Supervisor Seaver?
I'm sorry, I'm not opposed, and I apologize for this. Could we go back to the previous resolution for a moment?
Well, we just voted on this one, so I don't see any reason we can't pop back to it.
Sorry, I wasn't quick enough. Joy, I'm a little confused by the Resolution 198 of 2015 that you're asking to be extended. On Friday, we just approved 197 of 2016, which was, again, with the Legal Aid Society of Northeastern New York, in the amount of about $7,000. So, is this, we've already approved one last Friday, this looks...
It didn't approve the increase, it only approved the contract extension, because both contracts are due to expire April 30th.
So that was a contract extension, and this is now is an increase to that contract
Supervisor
extension.
Seaver, the county attorney can offer some clarification as
I can
well.
offer some clarification, Supervisor. Thank you, Chairman. Both of these entities are seeking an increase in their contracts for next year. They both expire April 30th of this year, so there's going to be a gap. What the full board passed last week was a 30-day extender for the Legal Aid Society. They've agreed to do a 30-day extender on the same terms as the current contract, so it would be a little over $7,000 for the 30 days. This would be another full-term contract at the increased price. I spoke to Ms. Feathers from the Rural Law Center, and they're going to hold up the appeals during that time while we try to get a new contract in place with the May meeting. And I spoke to Ms. Moy from the Legal Aid Society, and they agreed to continue for 30 days on the same terms while we try to get a new contract in place.
Okay, so that, may I?
Yep.
That answers my question regarding the resolution we just approved, but my second question, I guess, is, do we have, I can see it's awarded to Legal Aid Society, but do we go out, I know we go out to bid on other things, or out asking if anyone's interested. I mean, how do we know there aren't private entities or other individuals that would be interested in the position of conflict defender?
There may be, I don't know what our bid process was the last time, it was a few years ago, I wasn't here, I don't know what the solicitation of bids was. I do know that, from my experience, that trying to find private attorneys to take these cases outside of very few firms in the area is difficult. It's not that we need to cut down the people who are getting these referrals, it's that we need to increase the pool of people who will accept the referrals.
I can answer your question, Rachel. Thank you. We did go out to bid on 3 different occasions. I think we managed to have contracts in place for 3 or 4 years before the Bar Association and the state determined those contracts were illegal because there was no plan in place. So those conflict defenders went bye-bye, and we've never been able to get them back, because we're still waiting for the state to resubmit our policies. I can't remember what that's called. Do you recall, Brian? That Amy's probably got the file. But we're still waiting to hear back. So we haven't gotten approval to move forward so that we can have a block for several attorneys at a firm, or one attorney that will take over one particular court, because that was saving us a considerable amount of money. And I did that in 2006, and then we got whacked just a couple of years later.
One more.
Is there a way that we can help with that, or to, you know, I mean, it seems to me that there are some cost-saving measures there that you've identified.
Oh,
and
absolutely.
what can we do to support those efforts to try and move that along?
We could try and get together with Amy Bartlett. I know she's got all that information. She's not here very often, but, I mean, if you can make arrangements, I'd be glad to come and meet with you whenever you need.
I'll talk with Brian if that's okay with Supervisor
That sounds
Wood.
fine. Thank you. All right, anything else? Assigned counsel is all set? All right, and then at this time, we will need to have an executive session to discuss the employment history of a particular individual in the DA's office.
That's correct.
Motion by Supervisor Simpson, do we have a second? Supervisor Frazier, all those in favor? Aye. Any opposed? Carries. All right, we're back from executive session. No action was taken in executive session. At this time, I'd like to ask for a motion to enter into a settlement agreement.
Settle an employee discipline matter.
An employee discipline matter is how we're going to term that. Do we have a motion? Supervisor McDonald, seconded by Supervisor Dickinson. Any discussion? Hearing none. All those in favor?
Aye.
Any opposed? Carries. And now that we're significantly late, I have a motion to adjourn. Motion by Supervisor Dickinson, seconded by Supervisor Simpson. All those in favor?
Aye.
Thank you.
Quite good.
Amanda asked me and I said, what?
Let's read the page.